Great. Well, thank you very much. Good afternoon. As I said, it's nice to see some familiar faces, quite a few familiar names, if not faces. So this is in the section of talking of those who bring clients to mediation. And we now have 10 of us, including me, 8 other than myself and Sarah. How many of you take clients to mediations? Then you're all in the right place. Okay, right. Well, I am going to do the talk because it's something. Why I give this talk is, and who I give it to. I give it generally to solicitors, to in-house counsel. Not an identical talk, but a very similar talk. And it's to encourage the use of mediation and to encourage professionals who effectively are mediation advocates as to what they should be doing, what they should be thinking, and how they should be approaching it. So I know if you are a mediator, it doesn't hurt to hear this and to see what my views are. They may coincide with your views, or you may have different views. But I have quite strong views about the use of mediation. And I have quite strong views about how mediation is not used as much as it should be used. And indeed, that it's not used as much and not encouraged as much by the individuals that I see very much as being the gatekeepers to mediation. And for me as a commercial mediator, that's solicitors. So this is very much designed for them. If you can, as Sarah said, if you can leave your screen on, it's much better than talking to a sort of a black square with a name in it. I should just say, there's nothing to do with the talk. This is I'm also an arbitrator, and today's a big day for the CIR, and I'm a trustee of the CIR. So I've been this morning on what is the CIR's Congress. So I've been the whole morning looking through. And this is a fantastic medium, and I've been remote mediating since March. But yesterday I actually did my first face-to-face mediation since March. And it really, I've been saying recently, be careful what you wish for, and being a little bit jaded of seeing everyone on LinkedIn saying, this is fantastic, our life will never change. We can just sit in our living rooms, our kitchens, our bedrooms, and not move anywhere else again. And feeling that we'd lost 40,000 years of social evolution in the progress. Having stepped into the real world and there being real people, albeit I couldn't touch them or go within 2 meters of them, it really brought home just how important face-to-face mediation is. We did things yesterday. The mediation went from 10 to 8. We did not settle, but we did things that we could not have done through the screen. That sounds terrible, doesn't it? But it was a totally different experience to what you get through the screen. So I hope we will adapt. Anyway, that's just by way of intro. Let me just bring up, because I'm going to use slides to talk us through this. So let me start, as I often do, with a joke. This is why I want to see as many of you as I can. I started talking about mediation going around in about 2015, 16. And I found this cartoon at that time, and I put it up for almost all of my talks. And it was really interesting watching you. There's no reaction. Yeah. And the first time I put it up, there was no reaction. The second, third, fourth, fifth, 20th time I've put it up, there's no reaction. And I realized I was listening to a program Radio 4, and they were talking about lawyers. And they were talking in rather disparaging terms, and then they got on to lawyers' jokes. And they said the thing about lawyer jokes is that lawyers don't find them funny, and non-lawyers don't think they're jokes. And there's something in that that sums this up. There's a reason why lawyers don't find this funny at all, because it says, children, let's settle this like adults. And the children say litigation. And the father who said the magic word settle, it's not a joke, because they've just given him the answer he's looking for. And so the response whenever I'm with lawyers is they don't find it funny, because, well, that's it. They've got it right. What's funny about that? And the clue is in that word, settle. And that is all that mediation is about. It is about settling disputes. And it gets dressed up as many different things, and it is used for many different reasons, or not used for many different reasons. But at the heart of it is simply settling a dispute. And for me, that's one of the issues in terms of the usage of it, of not using it, or when it is used, it is dealing with it. So what I'm going to cover, and I see sort of key issues, is, again, of course, this is meant for practitioners, is talking to your client about mediation, timing of mediation, choosing the mediator and fixing the mediation date, working with the mediator pre-mediation, preparation for the mediation day, relationship between litigation, mediation, litigators, and mediators, and what I call getting into settlement mode. And finally, using the mediator and the process. So let's start talking about your client, about mediation. And if none of you have clients, this is what you need to pass. None of you do this, then you need to pass this on to clients. And what I say predominantly to solicitors, in-house counsel, is talk about when you should say the word mediation. And in many, many cases, that word is not said at all at the beginning. You will really struggle to find the now very, very detailed initial letters that solicitors send out where they will talk about the word mediation. It is not something that comes to mind to a solicitor, or indeed to a barrister, to mention at the outset. And it really begs the question why, because what mediation is for is to settle a dispute. And I see no difference, using an analogy, when you have a rash and you go and see a doctor. What you are saying is, I wanted to be in a position where I was before I had the rash. And the doctor will give you cream, whatever, to put you back into that position. And there's no different from when clients go to lawyers and saying, everything was okay, but now I have this problem with X, Y, and Z, or they have this problem with me. What a client is really saying is, I was okay before this problem arose. But lawyers, instead of giving them the cream or the pills to put them back where they were, they take them on a very long journey. And by the time they get to the end of the journey, they've actually forgotten what the rash was, why they got a rash, and why they first came there, because all they're concerned with is actually the dispute and the litigation. And the mediation I did yesterday was very much like that. It's been going for 4 years. It's only 2 months away from trial. So saying the word mediation is what a lawyer who's saying to their client is, you've come to me with a problem, I want to find a way to bring it to an end, and this is one of the ways, and probably the quickest way. So when, as early as possible, and I think it should be at the very, very beginning. We often knock our American cousins for many reasons, but through my career, I worked with a lot of American attorneys, and I just said attorney with American accent then. They understand mediation. In fact, about 20 years ago, I was working on a case and there was an American attorney, and there were quite a few English lawyers, solicitors and barristers. And he turned around and said, you Brits just don't get mediation. He says, we do not treat it as something to be scared of. We treat it as something that is there, a service to be offered, an additional or a separate service to be offered. And we talk about it from the very beginning. So as early as possible. And why talk about it? Well, I've already covered that, because it amounts to one thing. You're saying, I can bring this dispute to an end. And for me, what are the benefits? And there's one benefit, and that is that the gift of settlement is the best gift that a lawyer can give to his or her client, and the gift of settlement is the gift that keeps on giving. So, is there ever a time to avoid such a discussion? Well, I'll be interested at the end if you think there is. I don't think there's. I can't see how there can ever be a time to say that there is this option to be used. I cannot see a downside, but someone may be able to tell me that there is a time. The one thing, the caveat that the American attorney said, he said there are some cases, and he worked for one of the massive firms over in the States. He said there are some cases that will never go to mediation that come through our doors, but they tend to be, and remember this is 20 years ago, he said they tend to be around the smoking litigation. They involve government or they involve drug companies. But aside from that, everything's there. And I think it's an ongoing discussion that has to be in place. You have to raise it at each time, at each stage of the mediation or throughout the mediation. And what's actually happening now, I think, is quite interesting, because what I have seen, and I'm not alone, many mediators have seen, it is a pickup of work recently, an uptake of work. And I've been talking to my solicitor friends, and what has been happening because of the pandemic is they've been contacted by their clients, and their clients have said, what's happening? When's my trial? And the solicitor is having to say, well, I'm not even sure we're going to get it on in 2021. It could be 2022. And they are then saying, well, what are you going to do for me? And the solicitors are saying, well, there is this thing called medication or meditation or something like that. We possibly could try that. And I am, of course, being facetious and joking, but I have seen more than one incident of clients who had not had mediation mentioned to them in the 1, 2, 3 years that they've been going through the dispute until quite recently. So timing of the mediation, what do I say always? How early on in the process? What's always thrown out is by lawyers, it can only have a mediation when a party has sufficient information on liability, quantum, etc., on risks, only when the parties have exchanged witness statements. And to all of that, I say, well, how about the sooner the better? There cannot be a rule, and there is not a rule that you have to have all of it. And so I've been, and those of you who know me, I've been for many years now a proponent of what I've called, and I'm not the only one calling it, early stage mediation. And there's absolutely no magic to early stage mediation. It's not a separate process. It's effectively what it says on the tin. It's having mediation at an early stage of a dispute, hopefully before litigation has been contemplated, but even if it has, and even if it started at a very early stage. And why would you go at an early stage? It's very simple, because you've walked in and you've got the rash on your arm, and you remember that you didn't have the rash on your arm before you went to your doctor, solicitor, etc. You remember what this dispute is actually about. And that is the thing that gets lost along the way. The actual reason why you're in dispute, the reason why the parties fell out, the reason why it arose, you can remember that much easier as a client at an early stage and focus on that. And if you are in an ongoing relationship, in terms of the sort of work I do, the commercial work I do, it is much better that you are talking about the dispute and any disputes that might arise in the future at that early stage, rather than when the contract, the project, whatever, is over. Again, are there any downsides? When I remember actually quite a few years ago, I was giving a talk in Chambers, and I had a similar slide to this, and someone from the back shouted out, "Are you seriously saying it's never too early to have a mediation?" I sort of had to think on my feet, and I said, well, I accept that there are times, and sometimes many times, when it is too early for the parties to actually reach a settlement of the dispute. But it can never be too early for parties to start talking about why they are in dispute. So it's difficult to see a downside. Again, the mediation I did yesterday, the downside for them, and we did not settle, we might this week, it's difficult to say. The downside was that they didn't start talking earlier. And the receiving party made the point, if they would have gone to mediation, I kid you not, at the end of 2017, 2018, the value of the dispute was about 40% of what it is now. And of course, the costs were a fraction of what they are now. So difficult to see downside. Benefits are obvious. You can bring the matter to a close sooner rather than later. And the question is, does it require anything different to work? And I think it requires just one thing, and that's a change of ethos. We have here in the UK very much an ethos of mediation simply being effectively, and in commercial mediation, I should say, being an adjunct to litigation. It doesn't stand on its own 2 feet. 9 times out of 10, it is already in the litigation process or some way down the pre-litigation process. And that stat may even be too low. It may be higher than 90%. So that's what it needs. So then comes, for me, and this is one of my pet things, it is if you are a professional and you're choosing a mediator, it's how the mediator is chosen. And I find this quite fascinating. Those of you who know me, I've been a barrister 30 plus years ago, 31 years ago. I sort of hate saying that because it reminds me how old I am. And I use mediation as counsel many times, but the choosing a mediator, aside from me saying this person, I recommend this, he or she, I wasn't involved, but I'm seeing it now. People come to chambers. And it's a big issue as to how the choice is made and who finds the mediator. And 9 times out of 10, I've said that number again, those who call into chambers to check my availability, rates, etc., know nothing about the case. And that's quite astonishing. And so it seems, and I was talking, I've given 2 in-house talks recently to the big London firms and said this, and one of them, actually, there were quite a few partners and we had a discussion about it. It is quite interesting that in terms of choosing a mediator, it is effectively a junior member of the team has said, someone says, find me a mediator. And they sometimes have lists, often have lists in firms, but often it's left to someone who doesn't know anything about the mediation. So when my clerks say, what is the subject matter? How many parties are there? What is the value? They are more often than not met with blank answer. I don't know, or I'm not sure I'm allowed to tell you that because I understand mediation is confidential. So it's quite a problem out there. The other thing is that there's no consideration in most cases to what the parties are looking for in terms of the type of mediation they want or the type of mediator they want. Do they want a straight facilitative mediator or an evaluative or transformative mediator? So all of us who mediate are facilitative mediators. I consider myself to be an evaluative mediator with a small e. What that means is I don't give the answer, but I do an awful lot in terms of reality checking and other modes to assist the parties with their own evaluation of the merits of the case. There are some mediators who call themselves transformative mediator. I'm not quite sure exactly what that means, except I'm not sure if I've seen it, except you transform the party's perception, but I think we all try and do that anyway. The other thing is, and it's another phrase that I coined, when I started being a neutral was I saw a huge distinction in the marketplace as a lawyer who used mediators for my clients between what I termed active and passive mediators. I myself personally favored the active mediators, and I put them into a smaller percentage compared to the passive mediators. And the active mediators actively drive the process going forward. A passive mediator, and some mediations are suited for a passive mediation, effectively leave a lot more to the parties in terms of driving it forward. And there are some mediators who believe that's the way it should be. Personally, I go for the active mode. And then there's the last one. That's the difficult one, but it's what does he or she, being the mediator, know about your type of dispute? And that is relevant for some, but not all. But for some cases, it is highly relevant. I do quite a lot of construction mediations, and they want to know that the person who's mediating doesn't have to be a lawyer, but they want to know that the person knows about construction disputes. So when they throw out phrases and terms, that the person doesn't just look blankly across and can engage with them. So that's something. Hence the question of my clerk to people phoning up, what type of mediation is it? It doesn't help when they say, I don't know. Yeah. So that's choosing a mediator. Then what about working with the mediator pre-mediation day? And this is sort of it's a bit of a wish list, I'd say, as a mediator. And the first is that any good mediator will engage with the parties, in my view, prior to the mediation day. I think that's becoming more and more common. It wasn't common, certainly wasn't common 10, 15 years ago. You didn't have a word with the mediator until the actual day, but that's becoming more and more common. And the key, I think, is to use the mediator to assist in the preparation for the mediation. I still find that's quite rare that happens. And so what is so often going on in the background, it is, or can be, arguments. It can be arguments over dates for exchange, even if the mediator has said, I'd like to see something on a certain day. But more often than not, it's arguments over the mediation bundle. And they are a complete and utter waste of time. And if I sense that is happening, and I tell them when I'm engaged and I have a call with them or a Zoom call with them, I tell them, don't waste your time on arguing about the mediation bundle. If once I want something in, put it in, because they can always, if you don't want it in, the other side can always give it to me, or give it to me separately. But the mediator can assist in that. And so if there is a dispute, I encourage people to come forward and basically avoid disputes over the process and the preparation, because that is an absolute waste of the mediation time. The interesting one is this is respond to requests by the mediator. And I find that, I mean, I personally engage with parts of the mediation, quite a lot before the mediation. But there are times when that falls on deaf ears, and you're then playing catch up when you actually do engage. So that's my advice is respond, because there's a reason why the mediator is asking for X, Y, or Z. Making proper use of the preliminary telephone video conference calls, for me, this has been, as much as I said how amazing it was having a face-to-face, the Zoom calls have been incredible, because it means prior to the actual mediation day, you can cover a lot of ground. In addition to explaining how Zoom works, that most people now seem to know, you can get out of the way the confidentiality, explanation of the confidentiality issues, etc., and indeed discuss the dispute. But that is dependent on the participants being willing to make proper use of it. So the one thing I do is I encourage that clients are on the calls and the video calls. And that's at times met with some resistance by solicitors. But generally speaking, I think people are getting more used to it. And there is the great advantage of this is when you have the client on and you do what I'm doing now and you stare at that green dot, you are talking directly to that client without their solicitor sitting next to them, albeit they're somewhere else on the screen, because all they're doing is looking at you and nothing else. So a lot can be covered. And the bottom one, which is involve your clients at each and every stage. And when I give a talk with a similar slide to this, and I would say to the audience, what's wrong with this slide? And most times there'd never be the answer that I was looking for. And that is that it took me 6 points to get to the word client. When the client, this is actually the client's mediation. And so really that should be at the top. It should be the client who is the person who's involved from the very beginning. So preparation. This one is quite simple. And what you need to do is prepare and prepare and prepare. Any guesses for what's coming next? I saw Martin even muted. I could hear what you were saying. It is something that for whatever reason, the level of preparation does not match what perhaps it would if you were going into battle in trial. It's not going to be the same, but let me put it, there's a level of lack of preparation that happens now. So my preparation tips are, and you'll see I've now put it at the top, is start with the client. And that's quite rare, because a solicitor, a barrister will sit in their room or their home, their kitchen, wherever it is now, and they'll start the preparation. And they won't even think about calling up their client, but this is the client's mediation. And it's very difficult how you could think that you can start something that is only designed to settle a case, to negotiation and settlement, without actually talking to the client about what it is they want. Not what you think they might want, but what it is they want. And so a big thing is not treat it the same way as you would for court, which is often a problem. You of course have to understand your own case and the merits of the other side's case, and it's the latter bit that's important to take on board when you're going through. But no one in the real world enters into a negotiation before having a thought about what am I trying to achieve. I may not get it. I may not get the negotiated final I want, but what is it I'm trying to? So thought needs to go in preparation as to what type of settlement might be possible. And what I say is think in negotiation and settlement terms, and I'll come back to that, because that I think is the key for clients and it's the key for mediators, and it's where both go wrong. In my view, is not thinking in negotiation and settlement terms at all times. And that's, I'm not sure I meant it to be in caps or not. It's produce documents for mediation, not for trial. So that means I stopped calling them position papers, because I don't want position. I call them your statement for mediation. I told solicitors, barristers, whatever, individuals to produce their statement for mediation. It's a document that is relevant to the mediation, what you want to happen at the mediation. I remind them, I can read the pleadings. If there are pleadings, I know what the issues are in the case. I want to hear what your views are as to the mediation and what you want to achieve at the mediation. And that's really important. And so I'm going to run through this because I often put it in, because the one thing that needs to be borne in mind and perhaps left behind is in terms of the relationship and understanding the relationship between mediation, litigation, and mediators and litigators. And the first point is that lawyers' work is conducted in determination mode and not resolution or settlement mode. And there's nothing, that's how lawyers work. It's not a criticism of lawyers. That's just a matter of fact. And the case, any case is prepared on the basis of the determinator will make a determination. That determinator, he or she being the judge or being an arbitrator or arbitrators, will make a determination. And evidence gathering, pleadings, etc., are all done on the basis of attempting to prove a case or disprove the other side's case. And as a result, the mediation is often treated simply as, I think I've used the phrase already, as adjunct to the, it should be typo there, it should be adjunct to the litigation process. And if it is just an add-on to the litigation process, then it becomes a continuation of it. With lawyers seeing it simply as part of the process that may or may not end, but it's just part of the process that sometimes that we just have to go through. And the effects of this in practice are seen in many mediations, and that is that lawyers will act as if they're in litigation or arbitration, but there's no procedural framework for it. So it doesn't have the same sort of formality. It shouldn't be happening, but it's far worse than when it happens in litigation and arbitration. So personally, what I've done is I no longer have opening joint sessions. I still believe in joint sessions, but I won't have an opening one, especially if there are, if I sense that all the lawyers want to do is repeat what's in the pleadings. And what you get, and why I avoid it, is because what I think everyone in the mediation needs to do is to avoid adversarial posturing and concentration on legal positions, on factual arguments, which are often the lawyer's own arguments. It's quite incredible how many times I will be in a party's room or in a party's virtual breakout room, and I will be discussing a factual element of the dispute, and I will get to the end of my question and the lawyer will answer it. And I have to remind the lawyer that they actually weren't there, or they weren't in the library with Colonel Mustard with the lead pipe on the day. It was someone else, and maybe the person who's sitting next to them can probably better answer that question. All this leads to an inability to make concessions, acknowledge weaknesses in the case, ignore the merits of the other side's case. And that's a huge, it's a huge thing, because it's this carrying on as if you're in litigation and not taking the step outside the litigation process and stepping into this new process. And the further you have gone down this path as a lawyer, the harder it is. And I put a mirror up to myself. I was that lawyer in the room. I was that counsel in the room who would be banging my saber on the table and saying how right I was, how wrong the other side was, how good we were, how bad that they were. So it's not an easy thing to do, and it's almost something that is learned behavior, I'd say, but it needs to be done if it is to be a successful mediation. The other thing to avoid, which happens in many, if there's a lot of emotions running high, is the good faith arguments. Basically, we're good, they're bad. And I try and quash that myself as a mediator by telling them it doesn't matter what room I'm in. I say, when I'm in your room, everything you tell me is right, but understand when I'm in their room, everything they tell me is right. And you don't have to tell me that you're right, you're good, and they're bad. I'm just going to take it. I'll take it as read. And the other thing is what I call the fishing expeditions and spinning the mediator. And they're two different things. There just wasn't enough room on the slide. The fishing expeditions is the party that decides they have to go to mediation because of the consequences maybe, but they're going to use it as an opportunity not to settle, but to find out the other side. That's a complete waste of time, a waste of time and a waste of costs. The more usual one is the spinning the mediator. And I think the more I get known as a mediator, the less that is happening. But at the beginning, I certainly remember a few years ago, I remember a solicitor who had used me as counsel on several occasions, retained me as the mediator. And in our first private session, he said to me, "We retained you, Andrew, so you can go into the other room and tell them they're wrong." And it came as quite a shock when I had to say, well, I won't be doing that. But that, a lot of people think they can spin the mediator, and some mediators can be spun. So it happens, and it happens for a reason. So what about mediation day pitfalls itself? Well, there are many, to say the least. And the first, and I'm not going to repeat them all, is the level of preparation. There's nothing worse when you get there and you see that those who are there are not adequately prepared. It may happen that a junior member of the team is incredibly prepared, but a senior member of the team is not prepared. That could be the lawyers, it could be the commercial people, exactly the same, that someone who has authority is sent but actually doesn't know much about the case. And then there's the attendees, and that I think is a difficult one because it's not unusual to be in a mediation and realize that someone else should be there who's not there, but it is something that should be given thought to. You can't always get it right. Some people can't attend when they're face-to-face. Some people have to be at the end of a phone call, but it is important. The worst thing that happens, and has happened to me, is that I had a mediation where on both sides there were at least 5 people, excluding the solicitors, but in both rooms there wasn't a single person who could talk about what actually happened. Not one person in either room was involved in the actual happening of the dispute itself. So the client-lawyer relationship is really important, and this is my warning always to solicitors, is going back to where we were about involve your client, is have the discussions, because it's a wonderful moment in the mediation, and I've seen it on several occasions when the client turns to their solicitor or barrister and says, "You never told me that." That's incredibly bad for any lawyer. So it's important, and it's important to think about past advice, because that's going to be different to the advice you're going to give at mediation. So you might as well start saying the sort of advice you're going to give. Lack of authority in respect of a claim. You sign up to a mediation agreement as a client, as a solicitor, that you have the authority. Often you're signing it because to the best of your belief you have the authority, but if your authority in a £1 million claim is to go up to £10,000, it's unlikely that you actually do have authority. So the authority is not what you think a claim is worth. I have one where the quantum is put at, by the claimant, is put at in a couple of weeks, put it over £1 million. And the defendants have put that the quantum is 25,000. So the question is, it probably is not 25,000, but what authority is the defendant sending? We will see. Mode and scope of resolution. You've got to think about cost before you've got to think about CFAs. It's amazing how many times they're not. Conditional fee arrangements are quite rare now, but they need to, where they are, they need to be thought about. But for me, and this is the biggest pitfall in most mediations, is the parties not being in settlement mode. Not being, as you remember the cartoon, what mediation is all about. You're there to settle the case. So what is settlement mode. And for me, it's the art of negotiation. It's being in a position where you are thinking about negotiating a settlement. And it requires, the first thing is the change of ethos on the part of those conducting the mediation on part of their clients, from this determination mode to a self-determination. So to a self-determination mode. It's self-resolution of the dispute, whether by their client, but them, but it's not in this mode of simply saying it as loud as you can, we're right and they're wrong. That doesn't help, that doesn't resolve it. You're going to say that if you get to court, you're going to tell the judge that you're right and they're wrong. But a lawyer and a client has to move away from that mode and be in it. And it's the need to recognize that they're there to embark on a negotiation. And that's a difficult one. If you have been involved in a dispute as a lawyer and even as the client, it's difficult to suddenly think, well, they have caused me this much hassle for the last X number of years. I'm now here, I've got to put a different hat on and I've got to embark on this as a negotiation. But that's what is needed now. And the other thing to it is it's not a bilateral negotiation, but it is a facilitated negotiation. And again, you may have been relying on if you're a client, on your solicitor to write a letter, to talk to them. You may, as a lawyer, as a solicitor, that's what you have been doing, but that's failed. That's why you're in mediation. And so it's understanding that it is a facilitated negotiation, and the facilitation is by the mediator. But, and this is a huge but, you are not negotiating with the mediator. And that's something that is an issue, not necessarily a conscious, a subconscious issue for many users of mediation. So they will spend their time, as they would in front of a judge, trying to persuade the mediator that they are right and they are wrong, and that's nowhere. Hence, my point that I make very early on is, what you don't need to persuade me. Whatever you tell me is right. So let's not go down that road. Let's talk about something else. And when I've been in audiences of solicitors, this line often gets a blank look. And the example I give, I remember when I sat there as counsel, and probably as counsel, I saw over 150 mediations. And a mediator, he or she would come into our room and would talk to us for 30 minutes, 1 hour, it doesn't matter how long. And whenever when the mediator left, there would always be someone, whether it be a lawyer, a client, someone in the group would say, that's great, I think the mediator really likes us. And when that happens, you know that that person, and probably more than that person, has missed the point. That wasn't to make them. There's only, as I understand, only a couple of you meant to like you, and that's your Facebook friends and your dog and possibly your kids, but that's about it. Yeah, the mediator is not there. Is not there to like you. You're there to use the mediator. So what is it? How does it translate? If you can get into a settlement, if you can be talking to the mediator about negotiation, you can be talking about what you want to happen, what could happen, etc. It starts earlier. It means your preparation is going to be focused on the end prize. It's not going to be focused on saying why the other side is wrong. It's focused on, we need to get X amount out of this. We need this solution. And that's what the lawyers and the clients should be focusing on from the beginning. It means that negotiation and settlement parameters are the driving force throughout this. And it means, for example, position statements become non-confrontational, non-positional, and they have the right balance. And they're conciliatory where they can be, and that's very important in any mediation. especially in a commercial mediation, it helps to be conciliatory. And it's the bit I've said a few times, is you're not seeking the whole time to prove your case and disprove a case. You park that, you put that to one side, and you find common interests and needs, not positions. And that is really important, because every single case there is a common interest. As difficult as it seems, and as I say, I don't know if we will achieve a settlement or not. There was a huge common interest yesterday, and there still is, and that is neither side wants to go to trial. And that's the driving force that will get the settlement before trial starts. It is that both sides, and the one thing I think towards the end, the penny started to drop, that they both were in the same camp on that. They can't agree on the figure, but they're both in the same camp on that. So how does this all work? And as I said, it's not a bilateral, it's a facilitator, it's using the mediator. And I guess this is one of the most important slides for me, because it's about using the mediator and the process. And the first thing, and this comes back, because I've directed everything at the lawyers in this talk and the clients, but the first thing is it requires trust on the part of the parties and the lawyers of the mediator. And the mediator has to earn that trust. And that's something I think is fundamental to being a good mediator. If you cannot get the parties to trust you, you cannot get a settlement. You cannot facilitate a settlement. They need to trust you. And that means, as a mediator, you need to do enough to make them trust you, and to make them work with you. You have to get them with that trust to understand that working with you is in the best interests of the clients, and it's in the client's best interest to work with you, to tell you the things they have to tell you, to share with you the issues. But also, and this comes back to me very much to how the lawyers treat it, is you have to allow the mediator to properly reality check. And that's where I see lots of lawyers fall down. And I spend a lot of time explaining to, especially to clients, what I am going to do, what I'm going to be doing, that I'm going to be making them at times feel uncomfortable, that I'm going to be pushing them in terms of certain of the issues, etc. And that is a great thing to be able to do, save when you get pushback on that. So you're working with the clients on something, you're really pushing making them reality check, getting to the position where they're going to have to change their perception of things. And a lawyer may step in and say, no, well, that's wrong anyway. That's wrong. Yeah. Judge will never find that. We've got really good evidence on that. And so it's just not being willing to engage properly with the process. And that's a pitfall, because it sort of recalibrates the client to suddenly think to move back into determination mode instead of that simple thing. As I said, I consider myself to be an evaluative mediator with a small e. So I won't say a judge is going to find that Mr. X did this or that. But what I will say is, I want you to tell me what happens if a judge finds that Mr. X did or did not put the plumbing fitting in the place he said he did. And it's that bit that when you get the interruption, they're not saying, well, he won't find that, it's impossible, we've got really good evidence. That they jolt the process back to where it was. So the key is allowing the mediator to facilitate a settlement. And that is difficult. It's very difficult as a lawyer who's got control over the dispute and, in a sense, control over a lot of the client's decisions, to actually allow the mediator to take over and take control of it. And the way that you have to is you have to allow the mediator to use his or her toolbox. And what I do at many of my talks is I say, look, a mediator, a good mediator has a toolbox. And if you take anything away about this talk and about mediators and mediation in general, it's what I want you to do is to go away and think of your mediator as being a Swiss Army knife. And the mediator has several tools that he or she can use in negotiating. So when you are in a room and when a mediator says, I'm going to go into the other room and I'm going to use the scissors, don't waste time saying, no, we think you should use the corkscrew, because the mediator knows what's going on in the other room. Can't tell you, but knows what's going on. So you've got to, as a lawyer, as a client, assuming the mediator's built up trust, is allow them to choose the tools. As I said, I give lots of talk to solicitors, and obviously part of it is selling myself. What I also then need to remind them is that not all mediators' toolboxes are necessarily the same, and some have a wider use of tools. At least that got a smile as the ones I can see. So that's it from me. I'm happy to take questions. I'd love to take them with you putting your mics on. What I'd like to do is, I've been speaking non-stop, is just to give you this. You're not allowed to Google, but I'll read it. I always believed that a lot of the troubles in the world would disappear if we were talking to each other instead of about each other. It's not Mahatma Gandhi, it's not Nelson Mandela. Put your mics on, you can tell me who it is, and then you can ask any questions you like. And no Googling it. Any offers?
It sounds like my wife.
Well, that's okay. Oh, if this, I'm going to put you out of your misery. If that was your wife, then Martin, there's quite a lot to tell us. Great. Thank you very much. I'm going to stop sharing the screen so I can see you all again.